This NRA convention is known as the largest gathering of Second Amendment supporters, with as many as 75,000 people.
Everybody, or the majority of people coming together, are all like-minded.
Large gathering, 70,000 people is an enormous turnout. So you can feel the energy building.
Consider this intriguing connection. The National Rifle Association, the American Civil Liberties Union, and 9 U.S. Supreme Court justices from 5 different presidential administrations. Quite a unique trio, wouldn't you agree? But despite their diverse backgrounds and perspectives, they found common ground in a recent unanimous Supreme Court ruling. This ruling shed light on a recent concern: the violation of the First Amendment right. The case involved a New York government official who allegedly pressured insurers and banks to cut ties with the NRA, an issue that both the NRA and the ACLU have been involved in. The legal saga revolves around Maria Vullo, the former head of New York's Department of Financial Services, and her actions following the tragic 2018 mass incident at Marjory Stoneman Douglas High School at Parkland, Florida. It's alleged that Vullo, in private discussions with insurance companies, hinted at applying enforcement selectively against those doing business with the NRA. This case serves as a reminder that even in the midst of divergent ideologies and agendas, the protection of fundamental rights remains a unifying concern.
The Supreme Court has sided with the National Rifle Association in a case involving New York State.
Liberal Justice Sonia Sotomayor wrote the high court opinion. The case stems from a lawsuit against a New York official who urged banks and insurance companies to cut ties with the NRA, siding with the National Rifle Association. Government officials cannot attempt to coerce private parties in order to punish or suppress views that the government disfavors.
NRA's free speech rights were violated by Maria Vullo, a former state financial regulator. Vullo violated the First Amendment by coercing regulated entities to stop doing business with the NRA and punish the group.
Use third parties as intermediaries to censor speech. And that was a principle that came out much earlier in Bantam books in the 60s.
Former President Donald Trump is scheduled to speak to the group. That'll be on Saturday.
Drawing comparisons, but Maria Vullo's actions didn't end there. She took further steps by sending out letters titled Guidance on Risk Management relating to the NRA and similar weapon promotion organizations to insurers and banks. In these letters, she urged them to assess and manage their risks, including reputational risks associated with their dealings with the NRA or similar gun promotion groups. She advised them to review their relationships with such organizations and to take swift action to mitigate these risks while promoting public health and safety. Additionally, in a joint press release with then-Governor Andrew Cuomo, they called on these companies to sever ties with the gun advocacy group. Some heeded their suggestion. The constitutional issue at hand mirrors that addressed in the case of Murphy versus Missouri. This case questions whether President Joe Biden's administration violated the First Amendment by urging social media companies to remove content it disagreed with. During the oral agreements in March, several justices seemed inclined to the notion that government officials were within their rights and hadn't exceeded their authority. They argued that officials were simply exercising their own freedom of speech to persuade these companies to align with their views, akin to a White House press secretary advocating for a particular stance to the media. David Cole, the ACLU's national legal director, who presented the case on behalf of the NRA, shared his sentiments, stating, "Today's ruling affirms that government officials should not misuse their regulatory authority to blacklist unpopular political organizations." The New York state officials involved, former Governor Andrew Cuomo and his top financial regulator Maria Vullo, made it clear that they aimed to retaliate against the NRA due to their disagreement with its stance on gun rights. The Supreme Court has unequivocally declared this action unconstitutional. As Justice Sotomayor pointed out in her opinion, the core of the First Amendment's free speech clause lies in understanding that discrimination based on viewpoint is particularly detrimental to a free and democratic society. The key takeaway is that the First Amendment bars government officials from selectively using their power to punish or suppress speech. ACLU's changing standing. Despite stark differences in ideology, the ACLU found itself advocating for the NRA, underscoring the broader principle of protecting the First Amendment rights of all advocacy groups. Throughout the nation, organizations committed to causes like racial justice, criminal legal reform, reproductive rights, and LGBTQ rights often come under fire from state and local officials who oppose their viewpoints. Allowing New York to blacklist a powerful organization such as the NRA would have emboldened government officials to target even more vulnerable groups, particularly those representing marginalized communities. This landmark victory isn't just for the NRA, but for the preservation of our First Amendment freedoms, remarked William A. Brewer III, counsel to the NRA. The ruling reaffirms what the NRA has long asserted. New York officials abused their authority to silence a political adversary. It stands as a triumph for the millions of NRA members and the foundational liberties that define our nation. What this means for Maria Vullo. The ruling permits the NRA to proceed with its lawsuit against Maria Vullo, who allegedly pressured banks and insurers to sever ties with the arms rights organizations in the aftermath of the 2018 Parkland incident, which claimed 17 lives. Government officials cannot coerce private entities to penalize or silence viewpoints they disagree with, wrote Justice Sonia Sotomayor, the most senior liberal on the court. Ultimately, the crucial lesson is that the First Amendment bars officials from selectively using their authority to stifle or punish speech, she added. At the core of the case was a meeting Vullo held with insurance giant Lloyd's of London in 2018, during which the NRA alleges she suggested the company could avoid prosecution of other violations if it cooperated in efforts against gun advocacy groups. Vullo attempted to downplay the significance of the meeting, contending in part that the NRA's account of events lacked specificity. Vullo, who served under Democratic former Governor Andrew Cuomo, argued that her enforcement actions targeted an insurance product prohibited in New York, third-party policies offered through the NRA covering personal injury and legal defense costs stemming from firearm use. Critics dubbed these policies murder insurance. The ruling offers guidance to government regulators, regardless of political affiliation, regarding the extent to which they can exert pressure on private companies engaged with contentious advocacy groups. An attorney representing Vullo expressed disappointment with the decision, but highlighted the possibility of the lower court reaffirming its prior ruling, which favored Vullo on different legal grounds. Ms. Vullo didn't infringe on anyone's First Amendment liberties, stated Neil Katyal, the attorney. She enforced insurance laws against admitted violations by insurance entities, and communities like those issued by Ms. Vullo are routine and essential tools regulators employ to inform and guide the entities under their oversight about potential risks. No mention of Biden's case. The court's ruling overlooked another pending and related case regarding whether the Biden administration exerted undue pressure on social media platforms like X and Facebook to remove content deemed as misinformation. Both cases were presented on the same day in March. Although the NRA is typically associated with Supreme Court debates on the Second Amendment, it found uncommon allies in the First Amendment assertion. The American Civil Liberties Union, often on the opposing side of the NRA in gun-related debates, agreed to advocate for the NRA before the Supreme Court. Initially, a U.S. District Court rejected some of the NRA's claims but allowed its First Amendment arguments against Vullo to proceed. However, the Second U.S. Court of Appeals overturned this decision, determining that Vullo's actions weren't coercive. Additionally, it ruled that Vullo was eligible for qualified immunity, a legal principle protecting government officials from lawsuits in certain circumstances. The NRA primarily leaned on a 1963 Supreme Court ruling, Bantam Books v. Sullivan, which addressed a Rhode Island Commission's report to report distributors to the police for selling books considered obscene. The Supreme Court ruled that such informal censorship violated the Constitution.
NRA's free speech rights were violated by Maria Vullo, a former state financial regulator. Vullo violated the First Amendment by coercing regulated entities to stop doing business with the NRA and punish the group.
Use third parties as intermediaries to censor speech. And that was a principle that came out much earlier in Bantam Books in the 60s.
Former President Donald Trump is scheduled to speak to the group. That'll be on Saturday.
Persuasion into coercion. In the pivotal moment that tilted the scales in NRA versus Vullo, the court unanimously declared that Vullo's actions, as outlined by the NRA, had transitioned from persuasion to coercion. Government officials cannot engage in attempts to coerce private entities to punish or suppress viewpoints disapproved by the government, Justice Sonia Sotomayor wrote. She asserted that the NRA had presented a plausible case that Maria Vullo had indeed done so. With this decision, the case returns to the Second Circuit, which still holds the authority to grant Vullo qualified immunity, a legal principle shielding government officials from lawsuits like the NRA's if the alleged misconduct hasn't been clearly established in prior legal precedents. This possibility remains likely given that the Second Amendment's initial ruling not only determined that Vullo hadn't violated the Constitution, a stance the Supreme Court contradicted, but also suggested that if she had, qualified immunity would protect her from the NRA's claims. Yet, it's challenging to conceive a more blatant infringement of the Constitution than the misuse of governmental authority to stifle advocacy disliked by the state. The purported rationale for qualified immunity is that publicly funded officials should have a clear understanding that their actions are unlawful before a victim can seek recourse. To argue that a government agent couldn't grasp the boundaries of the First Amendment in this scenario is deeply concerning. For many, it's challenging to disentangle the constitutional debate from the ideological context. The NRA, for instance, is widely recognized as one of the most divisive lobbying organizations in the nation. Its core issue, ammunition rights, tends to evoke impassioned responses rather than rational discourse. Additionally, it's evolved into more than just a pro-firearms group, aligning itself closely with the Republican Party and its associated identity politics, thereby alienating significant portions of the population, and that's putting it mildly. On the other end of the political spectrum, there's a parallel narrative with another prominent organization, the ACLU. Once revered as a steadfast defender of free speech, the ACLU famously defended the First Amendment rights of Nazis, showcasing its commitment to principles over politics. However, in contemporary times, it has sometimes found itself at odds with civil liberties when those principles clash with progressive agendas, a paradoxical stance considering its name. Despite any personal animosity towards either or both organizations, the convergence of the NRA and the ACLU in this case underscores the nonpartisan nature of certain issues, such as the sanctity of the First Amendment. Well guys, that's going to do it for this video. See you next time, and bye for now.